I like, Joseph, how he is bringing up what the defense failed to show. Now, they don't have to prove anything, but they did make some promises in this case.
Exactly, yes. And so broken promises, empty promise from anybody, any side, in opening statement that doesn't bear truth throughout the trial is definitely used by the opponent in closing argument, and he's doing an excellent job at that. He's also taking the passion away from the case that the defense used in its closing statement, closing argument. He's going very clinically through a timeline and very methodically detailing how the defendant on trial here is the only, or is the most reasonable explanation, the only reasonable explanation for how these fatal injuries occurred.
Part of the promising in the opening, I think, might have been related to a potential defendant on the stand scenario, because there are things that she would have been able to articulate. She decided not to take the stand. She doesn't have a great look, one could argue, in the courtroom. Those text messages are as horrible as you can get. She's a young woman. How do you navigate that decision, getting her up there to humanize her and just to say, I didn't do it?
It's really, really difficult. Most defense attorneys, most very, very good defense attorneys have a blanket rule of, I will not put my client on the stand. There's a level above that. It's very, very minority of defense attorneys that say, look, I will put my client on the stand. I don't know the situation here. A lot of times I think of the trial like a spotlight. When it's the burden is on the government, you have the spotlight on their side of the room. It's on the prosecutor the whole time. When you put your defendant, the accused, up on the stand, then the spotlight shifts to that person. And so it kind of shifts the burden. And that's why most people don't put the accused on the stand when in trial. Again, I don't do that as a rule. I like to put my client on the stand. Here, what it tells me is that there was a lot of careful thought put into the decision. Then again, it could have been absolutely her decision. The defense attorney might have said, I want you to testify, and if she says no, you can't do anything about it.
Yeah, great spotlight analogy, Joseph. We've got to get to our break. When we come back, we are going to hear more of this rebuttal argument. The prosecution really kept their rebuttal